breach of 13(2), it's for the court to declare. For there may be so many laws which may not be applicable to non-citizens, may be applicable only to citizens. Then why should that consequence fall?
So it is for the court to either save
Yes.
all the consequences of the declaration of ordinance or give it untrammeled effect,
Trammeled effect.
which the court will say everything goes.
Yes.
The court may say, well, we'll do it prospectively, or that we will save transactions which have taken place under the law. That it has a variety of options open.
It's a variety of options. The power of declaration.
Have taken place under the law. Say people have been regularized under a law which is found to be void. May say that it will not affect.
Fundamental right was.
Question which arose before the 7-judge bench in the ordinances case. What happens when an ordinance
Yes.
is either held to lapse or an ordinance is held to be a fraud on power? What happens to the consequences which took place when the ordinance was in operation? One view was that, well, those consequences survive because they were made by a constitutional authority which had the power to make that ordinance.
Yes.
So we applied the test of public interest.
Yes.
Justice Gajendra Gadkar took a very clear view in the sense that he said everything which was done would survive. So we took a more nuanced view in Krishna Kumar Singh and said it will depend upon how the court perceives it. You may apply the test of public interest and save consequences, even under an ordinance which has otherwise been held to be void or to have lapsed.
The lordships,
Yes.
your lordships went to the extent of saying that the ordinance making power does not contemplate creation of a permanent state of affairs. Because the ordinance has to be placed before the House, then the House can disapprove it. And then the executive can never say, I have created a permanent state of affairs. To hell with it, whether you have passed it or not passed it or approved or disapproved. So parliamentary democracy demands that will prevails.
Because it is an exception to the lawmaking power of the legislature
Yes.
or the parliament.
Yes.
So there can't be an.
And then later on to say that even though you have
Your
declared it,
submission then in summation is this, that what
what will say this?
Later.
Later. Your lordships have said in Keshwanan that on a case-to-case basis, your lordship will decide.
point now. Would you like to just show us, as my learned brother, Mr. Rishikesh Roy was asking the note which you would like to just read out that, how you have formulated it?
Which volume and which? Volume 2N, my lord, deals with this part. If I may just draw my lord's attention before reading, my lord, to one more aspect of it, that 368 says that in terms that you may amend by addition, variation, or repeal. Even if these words were not there, the word amend will include all these forms. But they did not leave it for implication, expressly mentioned. Now, this is an additional alternative submission that in this case, we have to look at the nature of Section 4. As my lord, the Chief Justice said that it was a case of expansion, enlargement. So the intent was not to, the intention of the Parliament in introducing 42nd Amendment Bill was not to simply sit or repeal unamended 31C. The intention was to add, to bring in some more directive principles for the entirety of Part 4, in addition to 39B and C.